We are going to move right into our next interactive session with our Kahoot Let's Talk About Law session. I'd like to introduce our host, Jack Burton. Jack is the Associate Editor of Rock Road and Crane and Hoist Canada, and Jack is going to introduce us to our speakers. So welcome, Jack.
Thank you, Danielle, and once again to all of our speakers. It's been a great afternoon so far. As mentioned, I'm Jack Burton. I'm the Associate Editor for Annex's Rock to Road and Crane and Hoist publications, and I'm very excited and honored today to be hosting the interactive Kahoot session, Let's Talk Law. So for those of you who are not familiar with Kahoot, it's an online quiz platform that we'll be using to test our knowledge and learn a thing or two about the legal matters that intersect with today's topics of women in construction. Questions will be shown on the screen by our dear Kahoot master, Anthony, and the audience, that's you, will have around 30 seconds to respond with what you think the answer is. When the time runs out, the answer will be revealed, which brings us to what I'm most looking forward to. Luiza Vikhnovich, a lawyer at Sherrard, Kuzz, and an expert in employment law, will offer her insights to the answers behind these questions and how these issues can best be handled and navigated in your workplace. Everyone, please give a warm welcome to Luiza.
Hi, everyone. It's a pleasure to be here. Thank you, Jack.
Luiza is a member of the Association of Workplace Investigators, the Law Society of Ontario, the Canadian Bar Association, and the Ontario Bar Association. While we're very thankful to have her informed insights here today, I must clarify that what she is here to provide is a learning opportunity and not legal advice. Anyway, with all that being said, this is where you, the audience, comes in. So please follow the link on screen, in the chat, or scan the QR code with your phone to be able to provide your Kahoot answers. And while we're waiting for things to fill up, Luiza, why don't you just tell us a little bit about yourself and what it is that you do?
Absolutely. Thanks so much for that really warm introduction, Jack. As you mentioned, I'm a lawyer with Sherrard Kuzz. I help advise employers on the day-to-day workplace operations, help them manage their employees. A large part of my practice involves health and safety related work and human rights related work. It could be everything from investigating critical injuries on site, helping draft policies, investigating complaints of discrimination and harassment, and advising just again on the day-to-day operations.
Wonderful. Let's give it about 10 more seconds. Last call for the Kahoot time for everybody. And all right, I think we have everyone. So thank you once again. Oh, we just got a bunch more. All right, so let's move things forward now that we have the Kahoot room filling up. And take us to the first question, Kahoot Master. All right, so question number 1. According to a survey by the Canadian Association of Women in Construction, what percentage of women across Canada's construction industry have experienced sexual harassment or discrimination in the workplace? Your options are 45%, 68%, 80%, or 92%. Once again, that's according to a survey by the Canadian Association of Women in Construction. What percentage of women across Canada's construction industry have experienced sexual harassment or discrimination in their workplaces? All right. So the majority of people went with 80. The answer to that is actually 92. So 92% of women in construction, as a part of this survey, have claimed to have experienced sexual harassment or discrimination in their place of work. So clearly, this is a widespread issue. And I think for the sake of contextualizing today's discussions, it could be quite useful to hear from you, Luiza, just about what you've seen of this problem across your own work and clients across the industry.
Yeah, absolutely. I think for the most part, law tends to be a bit more reactive rather than proactive. So in the way that, I've kind of seen sexual harassment come across my desk in terms of the files that I've worked on, I really see it surface in 2 major ways. One is when complaints are made externally, for example, to the Human Rights Tribunal of Ontario, in the form of an application. So that's kind of one way in which, we're kind of after the fact trying to figure out what happened and whether or not the sexual harassment occurred and how it was addressed, if at all, at the time. The other way in which I see it, and the way that's a little bit more manageable, is when it comes in the form of a complaint that's made by a current employee, and the employer is looking to retain counsel to essentially conduct an investigation. So those are really the two ways that I think sexual harassment comes up more often than not, and really we're in a position most of the time where we're reacting to whether or not it had actually occurred in the first place.
Fair enough. Well, thank you so much for that, Luiza. So now that we have kind of an overview of this issue, let's look to our next question to try and understand maybe some of the nuances behind it. So question 2, true or false, comments or conducts must be of a sexual nature to constitute sexual harassment. That's true or false, comments or conducts must be of a sexual nature to constitute sexual harassment. All right, we're down to 5, 4, 3, 2, and 1. The answer, and it seems like most of you are on the money with that, is false. So Luiza, do you have any insights kind of with regards to this expanded umbrella of, maybe what constitutes harassment beyond comments of a sexual nature or conduct within that sort of area? Or, any examples from outside of these more common definitions that you've seen in cases?
Yeah, I think it's a really interesting question because it comes up a lot and it can be surprising for some, although most of our audience picked up on it. So let's just maybe go back to the foundation of what is harassment. When we look at just the legal definition of harassment, what we're looking for is a course of comment or conduct that is vexatious and that is known or ought reasonably to be known to be unwelcome. When we add kind of that sexual component to it and we call it sexual harassment, really all that means is the presence of a ground, and that ground can be sex, gender, or gender identity. So it's not always the case that the conduct needs to be inherently sexual or of a sexual nature to amount to sexual harassment. A really good example actually comes out of guidance provided by the Ontario Human Rights Commission. So they give the example, picture a supervisor who's kind of picking on a female employee, making comments that single her out with respect to what she's wearing relative to her male coworkers. So that can be an example of, if you have repeat instances of that kind of comment or conduct, an effort to maybe exclude the female employee from the workplace, make her feel unwanted. That's something that in certain circumstances can amount to sexual harassment, even though there hasn't really been anything said that's explicitly sexual.
Fair enough. Have you noticed maybe within the more trade-oriented or construction-centric organizations that those kinds of forms of like gender discrimination as sexual harassment can come into play?
Yeah, I think that, we see it across the board, right? Like in construction settings, I think when we talk about PPE, for example, right? Now there's a requirement, or there will be coming soon, to ensure that there's properly fitting personal protective equipment in place. In the past, perhaps that would have been a basis to make comments, right, about things not being appropriately worn, right, or picking on female employees who aren't wearing PPE in the same way their male colleagues were. I think that's just a prime example of the kinds of circumstances that foster that kind of culture and comments. So it's certainly not unique, I think, across the board in different workplaces, but particularly in construction, that's how it can surface. Yes.
Fair enough. Well, thank you so much for that, Luiza. So, given the volume and nuance of this issue, let's look at employer best practices. So what should you do as an employer upon receiving a harassment complaint or upon becoming aware of that harassment? For this one, please select all options that apply. Speak to the complainant first, speak to the respondent first, speak with employees who might have knowledge of the circumstances, or investigate externally, or rather I should say and or. Once again, that's speak to the complainant first, speak to the respondent first, speak with employees who might have knowledge of these circumstances, or conduct an external investigation. All right, so kind of across the board there, but if you answered speak to the complainant first or investigate externally, you are correct. So Luiza, could you kind of tell me about how both of these actions represent a proper response in the workplace to sexual harassment complaints?
Of course. So the starting point for any investigation is always to speak with the complainant to really understand the exact nature and the scope of the allegations and the details around that complaint. there isn't necessarily a requirement to do that with external counsel's help, for example. The investigation can be conducted internally, but it's certainly an appropriate response to seek external help with it. And in any event, it would end up or result in an initial interview with the complainant. When it comes to conducting an investigation, it's really important that investigations are conducted appropriately in the circumstances. So what that means, and when we look at kind of the hallmarks of a fair and a procedurally fair investigation, it's really important that the respondent has a fair opportunity to respond. Picture the difference, for example, if an employee comes forward and makes a complaint of sexual harassment against an individual and says, he harassed me. A very bold allegation like that, it's difficult for the respondent to have a fair opportunity to respond to that because they're not really sure what they're responding to. Compare that, for example, with, on this day at this time in this location, you touched my that's a very different kind of complaint. It's much easier to respond. So that's why the starting point we always say is to interview the complainant. And then after that, you proceed with putting those allegations to the respondent, giving the opportunity for the respondent to respond. And in some cases, you might need to speak with witnesses, but the one thing I will flag is typically there are confidentiality concerns around investigations. And so it's really important not to involve people in an investigation prematurely, or if they don't need to be a part of that investigation. So that's just something to be mindful of, because I know that wasn't an option up there as one of the answers.
Yeah, so you really that was great advice with regards to kind of the clarity that needs to be established when it comes to like starting these conversations. What does a solid and good external investigation look like on that hand?
Yeah, so usually an external investigation is something like phoning us up. We parachute ourselves in. We're the ones who are meeting with employees, walking them through the process, right? We meet with the complainant, meet with the respondent. We do all the usual steps that would be done internally. The difference is that sometimes we're able to offer privileged investigations, and those are in certain circumstances, and it can be pretty much a huge benefit to employers. And that's definitely, a consideration that needs to be made at the outset, and something that we're happy to walk through in terms of, if there's circumstances that warrant that.
Amazing. And then you also mentioned kind of the confidentiality concerns that need to be honored around handling these issues. So are there any other improper actions or common errors that employers should be mindful of, when moving forward with these sorts of things?
Yeah, I think one of the things that we often see is employers sometimes forget when employees have complaints outstanding. Um, you know, a typical example is an employee has made a complaint, and separate and apart from the fact that they've made that complaint, there were performance issues, and so the employer might move to try to discipline the employee. That can sometimes be portrayed as being retaliatory conduct, which is a form of reprisal, and there's protections from that under various forms of legislation. So it often isn't the case that there's an intention to try to retaliate, but because things like that fall under the radar and we forget to track when complaints are being made, that can sometimes result in the optics or the appearance of reprisal. And so it's really important that employers, in conducting their investigations, if they are doing it internally, they remind all participants that there is freedom from reprisal as a result of having either made a complaint or participating in the process.
Awesome. Well, thank you for that, Luiza. And congratulations to Casey, Blue Goat, and Kitty for leading the pack, and to Beyonce for being our highest climber. Didn't know she joined us for this. But anyway, let's continue down this path of employer actions when it comes to these issues, kind of looking at the more strict legal requirements. So what kind of proactive measures is an employer legally required to implement to prevent sexual harassment in their workplace? Once again, please select all that apply. And your options are sexual harassment training for managerial or supervisory employees, awareness posters in the workplace, a violence and harassment policy, or implement language into employment agreements affirming company commitment to prevent sexual harassment in the workplace. Similar to the last one, multiple choice. Please choose all that apply when it comes to the legal requirements for preventing sexual harassment. All right, so once again, we have A and C, and the 14 who chose C are correct. A little trick question for you. we only have one correct answer to that, and that is to implement a violence and harassment policy. So Luiza, could you maybe get into the details of what the legislation says about this requirement, along with maybe some of the impacts that these other measures could have on a more voluntary basis?
Yeah. So as you noted, only C was actually legally required. You do have to have a workplace violence and harassment policy. There is a requirement to provide training in that policy, but that's separate and apart from just training in and of itself. So all the other measures that were listed up there on the screen are voluntary measures that an employer can elect to do. And it's certainly, we would encourage you as an employer to do all of those things. Can be quite helpful. I know in an effort to attract retention, we were talking a little bit about that earlier today. Sometimes employers are wanting to put statements like that into employment agreements. The one thing that I would flag is, when you're thinking about your employment agreement, we typically pull out any language that isn't absolutely necessary. We try to keep those pretty skinny and pretty tight as to, what the actual terms and conditions of employment are. That kind of language is usually better included in something like an employee handbook that accompanies the employment agreement at the time that an employee is being hired. So it's certainly not to discourage anyone from kind of creating statements like that as part of their company ethos or their commitment, but just being mindful and careful about where that's being included.
Wonderful. And then kind of to the point of actually honoring this legal requirement, what are the necessary tenets or areas of coverage that a workplace violence and harassment policy must include or consider?
Yeah. So there are a number of measures, like prescribed requirements related to workplace violence and harassment policies under the legislation, under the Occupational Health and Safety Act, for example. In Ontario. In Ontario, the four really key requirements that at minimum your policy must have, it must set out the measures and procedures that are available to address risks. Essentially, you kind of want to do a hazard assessment or a risk assessment at the outset to see, possible ways in which violence or harassment could arise in the workplace. It needs to set out how employees can get immediate assistance in the event of an incident of workplace violence or harassment. There needs to be a reporting procedure available that's outlined in terms of, how an employee can come forward with a complaint. And there absolutely needs to be a mechanism that speaks to how those complaints are going to be investigated.
Amazing. Well, thank you so much for that, Luiza. And so now let's move on to kind of looking at the details from the employee side of things when it comes to reporting these incidents. Also, congratulations, Kitty, on dethroning KC. So if an employee who wishes to file a complaint with the Human Rights Tribunal of Ontario, how long do they have to file that complaint? And your options are 2 years, 1 year from the incident or from the last incident in a series of incidences, 2 years from the last incident, or the last 2 years from the incident or from the last incident in a series of incidences, or 1 year. Apologies for the word salad. That one's for my vegetarians in the audience.
No matter how many times I've said those options, by the way, I also do the same thing.
Incidences, it's a nice accoutrement. But anyway, the answer to that is actually B, which is 1 year from the incident or from the last incident in a series of incidences. But it does seem that most people went with the 2 years period. Is this a common, is there a lack of education around this sort of issue, Luiza?
If I were to guess, I'd posit the fact that people are probably considering the civil limitation period when it comes to filing actions civilly, and that might be the reason why there's a bit of confusion around that. But at the Human Rights Tribunal, it is actually 1 year from the last incident or the last incident in a series of incidents.
So then could you maybe kind of speak to the details of what is outlined in this limitation period and just what it actually looks like on a textual legal level?
Yeah, I mean, it's pretty, like, the language in the act is very, it's limited to just that. So it's section 34 that sets that out. But the one thing to be mindful of, and is often missed, is that there's actually also an exception to that. So the tribunal will accept applications beyond that 1 year limitation period, provided that the delay was in good faith and it doesn't result in substantial prejudice. And there is an onus on the applicant. So usually the employee, for example, who's bringing forward the complaint to demonstrate the fact that that delay was incurred in good faith. And what I can comment on, and that you won't find in the legislation, is that that's a really high bar for applicants to be able to make out. It's really not an excuse to say, for example, that you didn't know the law, or that you were waiting for other proceedings to wrap up. The tribunal basically looks at, what is the length of the delay, and perhaps was there a code-based reason for something impeding the ability to file the application in time. So really high bar to try to get out of that 1-year limitation period.
Well, thank you, Luiza. So let's continue to take a look at this legislation as it pertains to this issue, specifically in terms of what it covers and protects you from as a worker facing harassment in our next question. So under the Ontario Human Rights Code, every employee has a right to freedom from discrimination in the workplace by the employer or its agent or other employees because of each of the following except gender identity, gender expression, weight, or sexual orientation. So which of these is not, they are protected from discrimination against under the Ontario Human Rights Code? And the answer is weight. And once again, people seem to kind of know what's up with that one. So, one thing we've kind of learned so far is, a lot of these discriminatory actions, especially when it comes to, marginalized or intersectional workers, they overlap with one another. So Luiza, what would happen in an incident of harassment that, is weight related, but could be seen as gendered in nature?
Well, so if we're just kind of focusing right now at the moment for the purposes of the Ontario Human Rights Code, if an individual was bringing forward a complaint alleging that they were experiencing harassment or discrimination on the basis of weight, there is a possibility that if those comments or conduct were also somehow related to gender, or closely intertwined with gender, that the tribunal would still be prepared to find discrimination or harassment, notwithstanding the fact that weight technically isn't a protected ground. So helpfully, there's actually a case that the tribunal decided back in the 90s. The facts are a little bit unpleasant, but I will mention them because I think they illustrate the concept. So this was over the course of, I think, a 14-year period that a female employee was being harassed by a male coworker. The male coworker called her a fat cow on one occasion, would make like sound effects when she was walking, like waddle waddle or swish swish, to try to imitate the sound of her nylons rubbing against each other. And so ultimately, as you can imagine, that kind of conduct led her to resign from employment. And the tribunal still found that this was discriminatory. Again, even though we were looking at comments that were directed at her weight, the tribunal found that because gender played such a huge role in those comments and was closely intertwined with them, it was still protected. She was still protected from discrimination and harassment on that basis under the code. That being said, that analysis is separate from, what might still be covered, for example, under health and safety legislation, right? So if we're looking at kind of weight-based comments, and that are known or reasonably known to be unwelcome, right, and are made to try to ridicule or demean or embarrass an employee, those might still fall within the scope of protected or prohibited conduct under the health and safety legislation, even though, again, we're not looking at them in the context of weight and a protected ground under human rights legislation.
Thank you for that, Luiza. And congratulations to Kitty for continuing to defend the podium, and to RT on your hot streak of 4 correct answers in a row. So Luiza, you were talking about specific cases. So I'd like to maybe look at another specific case, specifically of harassment in a Canadian construction workplace, and just look to see what the impact of that looks like in terms of prosecution. So let's get on to our next question. So in Holmes v. Wayward, the complainant alleged that her supervisor sexually harassed her and failed to promote her when she did not reciprocate. She also alleged that her employment was terminated for not reciprocating. The Alberta Human Rights Commission found sexual harassment and awarded what amount in general damages? Your options are $5,000, $100,000, $75,000, or $20,000. So in this Canadian construction sexual harassment case, the Alberta Human Rights Commission found sexual harassment and awarded what amount in general damages? So most people said 100,000, but the answer to that is 20,000. So Luiza, could you maybe get a little more in depth as to, just from the perspective of a prosecutor, as to how they arrived at this outcome and this amount was kind of concluded?
Yeah, so this decision came out of the Alberta Human Rights Commission in 2021. So actually not that long ago. And I know we were expecting amounts to be higher, and they certainly can be when we're looking at, for example, if a termination or a cessation of employment is found to be discriminatory, when we're looking at, back wages that are awarded, sometimes that can increase the amount. But when we're looking at general damages figures, they're actually surprisingly lower than you would have expected. So I'm not entirely surprised by the response and the shock probably when it comes to those amounts. Just very quickly, this case was about a female employee who was working on the only female employee who was working on a construction crew as a general laborer. And her supervisor made a number of inappropriate comments to her, including, about her sexual practices and her history and her dating, and just very, very unpleasant. At a certain point, she raised a complaint. She was moved to a different work site. So thinking back to, again, some of our comments earlier from our panelists, that was the decision that the employer had made. Ultimately, she was disciplined. Her employment was terminated, but for a health and safety violation. And so she had tried to make the allegation that the termination was discriminatory, but the commission found that there was actually no link because the individuals on the next job site had no idea about the sexual harassment complaint that she'd filed. So the tribunal limited the damages award only to the finding of sexual harassment and not to the termination itself, which probably explains why it's a lower amount than what we would have expected.
Fair enough. Well, thank you for that very clear explanation, Luiza. So that leaves us with our final question, which we're going to take a look at discrimination kind of in the context of intersectionality. So let's get to that next question and see what we got. True or false? In a case involving sexual harassment, the Human Rights Tribunal of Ontario may consider intersectionality, i.e. the presence of discrimination on the basis of other grounds in addition to sex and gender, as a factor that supports a higher general damages remedy. So in the presence of intersectionality, does that lead to a higher general damages remedy? True or false? The answer is true, which once again, people seem to be on board with. So Luiza, could you kind of give any case examples of this issue as workplaces, continue to increase in diversity?
Absolutely. So in 2003, the Human Rights Tribunal of Ontario, in a decision called Baylis, Flannery, and DeWild, found that, findings of discrimination when we have multiple grounds can actually lead to a higher damages result. And in this particular case, I do want to quote directly from the tribunal here and congratulations to Kitty, by the way, as an aside.
Congratulations to Kitty.
I do want to quote directly from the tribunal here because I think this is such a powerful quote. The tribunal noted that the applicant in that case could have succeeded on either ground of race or sex, but the law must acknowledge that she is not a woman who happens to be Black or a Black person who happens to be female, but a Black woman. So I love that quote because I think it really kind of wraps up the decision very nicely in one line. But the idea, so just very briefly, this case was about a receptionist who worked at a physiotherapy clinic, a young Black woman. She had a number of complaints against the owner of the clinic, who had made incredibly inappropriate comments to her, asking her again about her sexual history and her practices with her husband. But importantly, there were comments that were very closely linked in sexuality and race. So like comments, again, just to give the example of, whether or not she found in her experience the sexual performance of men of a particular race were better than others. He would mention the fact that he happened to have an ex-Black girlfriend. So just comments that were incredibly inappropriate in the workplace. Understandably, she filed this complaint. The tribunal awarded, I think in total, damages in excess of $45,000. A part of that was the general damages award. The tribunal actually noted that they carved out the general damages award. So they said it was $35,000 total in general damages. $25,000 of that was in recognition of the sexual harassment complaint, and the $10,000 was in recognition of the racial discrimination and harassment she'd faced. So it actually lent itself to a higher general damages award overall.
Amazing. Well, thank you so much, Luiza. That is all we have for today for the Let's Talk Law session. But I'd like to thank Luiza, each and every one of you for participating, Kitty on the win. And yeah, huge thanks to you, Luiza, for helping us, stay informed on this issue and just really get into what it means for the workplace. So Luiza, just before we leave, where can people find you?
I just want to say thanks again for having me. And you can find me if you search me up on sherrardkuzz.com. You can find my profile there. I'm also available on LinkedIn and happy to chat or address any questions you might have.
Amazing. So thank you, Luiza. We are now going to hand things back to Danielle Labrie, our MC, to introduce our final session. Have a great afternoon, everybody.
Thank you.